Hey, what's going on, guys? I believe I should be live now. So I'm gonna wait for the delay to catch up, and you all just let me know if there's any kind of uh sync issues or anything before we get started, and then we'll go from there. Okay, now you can. Great. So BZ Watchdog, yes, I did. I believe I did get your emails on that. Obviously, as someone mentioned, I really can't talk anything specifically about this stuff. But uh, anyway, I want to get started. I want to get started and talk about damn commercials, huh? I got to figure out how to fix all that stuff. But I have to. I want to get started. I don't know if you all saw my interview with Professor Reinert. I actually did not. I have a lot of material. I did a lengthy interview with him. I wasn't going to put it all in one. I thought there was going to be a good way to use this, and what'll end up happening is I'm going to put it out right in a series of videos on specific topics. But for you all joining live, what I did want to do was I want to play a different portion of his interview that actually specifically discusses the notwithstanding clause and the derogation canon. And what I'm gonna do is I'm gonna play that right now. And so if you all have any questions or anything that comes up, just let me know. But it is a portion of my interview, so this is kind of like a sneak peek for you all because I obviously these are going to be portions that were not uh, originally in the video that I released. So
My argument is the reading we should give the notwithstanding clause is that Congress meant to establish a way to sue state and local officials for violations of federal rights without having any barrier imposed by state law. Now that
so
makes
we're
a lot of
talking about
sense,
the
right? We have to
notwithstanding
put
clause
ourselves
right
back in
now.
Congress's shoes in Reconstruction. The, the Congress of the 1870s did not trust states to enforce federal law, especially newly enacted and adopted federal amendments meant to protect especially newly emancipated black people, right? So that Congress did not trust states and localities to protect those rights. That Congress would not want state or local law to get in the way of its newly enacted federal rights. And so the notwithstanding clause is perfectly consistent with what Congress was trying to achieve.
So does that make sense to everybody? So the original reading, right? So the original text of what we know as the 42 USC 1983, which is what we use to sue government, right? State and local government officials. It was originally written with the notwithstanding clause, which specifically means that it's supposed to ignore state law. It's or state defenses and common law defenses because right this was right after emancipation, so the federal government wanted people to be able to sue state and local officials that were violating their rights. So originally that's how it was written, that's how it was intended, right? But as you know, if you watch the portion of the interview that I've already uh, released, somehow somebody who is compiling this just made that clause disappear. And so for that reason, as I'll show you later, it's a direct result of why today we have qualified immunity. So that's what he's getting at. He's talking about like, look, the original text has this language, and you go back in the mindset of what that Congress was doing, it makes perfect sense for Congress and the federal government to have no defenses available if you were to sue state and local officials for violating your rights. But as we know, that went away.
So that's piece one of the argument. Piece two of the argument is to the extent the Supreme Court originally located qualified immunity in state common law, this notwithstanding clause speaks pretty powerfully to an error in the court's analysis.
So some part of the reason, right, or part of the issues with qualified immunity, right, is courts consider it first because they see it as a threshold issue, right, as a jurisdictional issue. So is your understanding based on this notwithstanding clause and the way that the act was originally passed, was that there wasn't supposed to be that threshold issue of qualified immunity to be able to pursue the litigation?
Yeah, I mean, look, if my argument is right, then qualified immunity falls out of the picture. And so then the only question in a Section 1983 suit for damages is whether or not I've established a violation of my rights. And
So that's an important factor, right? So if the law was enforced as it's actually written, the only question should be, was there a violation of constitutional rights? And if you've been watching the handful of videos I've put out so far, you'll understand that the issue that we're getting right now is that courts are actually refusing or ignoring altogether that question, right? Because as discussed over and over, qualified immunity, to overcome it, there's two questions a court has to answer, and they can start with either one. The first is whether the first is whether uh, the first is whether there's a constitutional violation, which is what Professor Reinert's talking about, which should be the only question. And then the second question, of course, is whether that right or that conduct was clearly established. Basically, you have to find a case on point that's similar enough in facts. And based on those similarities, it would have given the officer or government official conduct or fair notice of beyond debate. It's beyond debate that their conduct would have violated rights. Courts always jump to that issue. Why? Because they're sitting there saying, hey, look, it's not clearly established, so you lose. It doesn't matter if there's a right violation or not. And that's obviously a concern because if you keep bringing all these cases forward, but courts never actually answer whether the conduct violates rights, then nothing ever gets clearly established. Everything always loses on the second prong. So, yep, that's right. Ballsy deep, notwithstanding equals overrides any conflicting terms. That's right. Specifically, it was intended to not account for, it was basically saying, hey, if you want to sue state or local officials, you get to do so regardless of any state law defenses, regardless of any common law defenses. So it was meant to basically allow people to walk right into court and to file a lawsuit, and the court only asks the question, was there a constitutional violation? If so, you get damages. That's what was supposed to happen back when this thing was written in 1871. But that's not what happened. Bulls. Bulls deep. Maybe I did that on purpose. I don't know. I don't read so good. So, yeah. Yep. We do have our, yeah, it's in gray, so it's kind of hard to see. But yeah, under duress, you're right. We have a ton of cases. That's actually a problem. The problem, of course, for these cases is qualified immunity. Qualified immunity in all of them are issues. And of course, statute of limitations are always issues as well, right? So and maybe I need to do something separate on this, but just so you all know, you have to look at anytime you think you have a violation, it depends on your state as to the statute of limitations. What the federal court does for a 1983 case is it looks to your personal injury statute under your state law. So every state is going to be up to what the legislature says. So in Texas, for example, uh, our personal injury statute of limitations is 2 years. So the courts here, the federal courts here, when I want to bring a civil rights suit, it has to be within 2 years of the date of the incident. Otherwise, it's barred, right? So that's part of the issue. So don't think there's just one statute of limitations issue across the board. I know I'm kind of digressing a little bit, but I'm going to go back to where it's like, hey, look, courts are now using qualified immunity as a threshold, as a jurisdictional issue. It's not even a defense issue, because if it was a defense, then who has the burden for a defense? Do you all know? Just waiting to see. Hey, pink camera magic. So the defense burden's on the defendant normally, right? If you want to bring a lawsuit against somebody, it's the defendant. If they want to say, "Oh, I have this defense," well, the burden's on them to prove it. But qualified immunity, the burden shifts to the plaintiffs, right? So the plaintiff has to establish that right there's a constitutional violation and that it's clearly established. So, uh, it's not really a defense question, even though it's kind of framed like a defense. It's actually more of a threshold jurisdictional issue. Why? Because immunity, right? You're saying you're immune from suit. And so the district court has to answer the question anytime it comes up: is this officer or government official immune from suit? So that's why I was asking Professor Reinert here and said, hey, look, so it's being treated as a threshold question today, right? 1983 qualified immunity. It's not a defense, but it sounds like that's not what was intended.
And we shouldn't be interposing this defense that Congress meant to override in the way of me seeking to vindicate my constitutional rights. It doesn't mean every case is going to win, right? It just means now the only question we're going to answer is, was there a violation of federal rights or not?
So I still don't understand though how nobody didn't catch this for over 150 years, right? You're talking about the Supreme
Crazy.
Court, thousands of lawyers, legal scholars, and everyone just missed this.
Yeah. Well, so let's go back to the history I was talking about early on, which is for the first. So we didn't really get a muscular deployment of Section 1983 as a tool for vindicating rights until after the Supreme Court's decision in Monroe in the 1960s, early 1960s. And so between 1871 and 1960, to the extent people were using the rights given by the 14th Amendment, they were using it often in defense, right? In defensive litigation, often in criminal.
So I realized that maybe my video, right? I'm still trying to figure out these videos and make them quick, make them straight to the point, and understand that sometimes I can get a little lawyerly in these things. And then, when there's phrases such as notwithstanding clause or, what the derogation canon, all these things are a lot, they're complicated, right? So I got to be careful how I present the information, but I figured, hey, that's what I'll use the live for. So the derogation canon is there's different canons or different legal theories, I would say, how courts are supposed to interpret statutes, right? Or it's specific when there's an issue with the civil rights statute, the court's going to apply a canon, a methodology for how they're going to interpret it. And so one of the methods that they used to really develop qualified immunity was the derogation canon. And what Professor Reinert is explaining here is that all the cases by the U.S. Supreme Court back in that day, the derogation canon was specifically meant to only apply to defenses. Essentially, what that means is oh, cool. Hey, pink camera magic. Yeah, let me get to you in a minute on that. So, what the derogation canon means on this is the court has to look at the legislative intent, and they say, hey, if they're silent on X, Y, and Z, then obviously they didn't mean to incorporate it. Well, what we have here is they're saying, well, one, the Supreme Court, when they were looking at the legislative intent for defenses, uh, they didn't read the right text of the statute. So they said defenses exist. So the first problem was they were looking at the text wrong. They were looking at the wrong text. And then the second issue, of course, was the fact that that derogation canon had never been used before to apply whether a defense exists. It was always whether a right exists. So that's what he was really getting at here. And I know a lot of that could get lost when I was kind of going back and looking. So if you all have any questions about any of this stuff, definitely let me know, because I I can nerd out on all this stuff all day, especially if it means I could get one step closer to getting rid of qualified immunity.
criminal cases, and every once in a while seeking injunctive relief. As I said earlier, there were a few cases where people brought voting rights were voting rights challenges and sought damages for being deprived of the right to vote based on their race. In those cases, I think we should think of as early Section 1983 cases. I don't know that the plaintiffs specifically, relied on Section 1983, but they are early Section 1983 cases. And if you go to those cases, no one ever talks about immunity doctrine. That is, I think for a long time, the assumption was, well, if you're going to actually sue for damages here, there isn't any immunity, any common law or good faith immunity. It wasn't until 1967 decision in Pearson that the Supreme Court first suggested that there would be some kind of good faith or qualified immunity. And there they just sort of pulled it out of this doctrine that says it's the other thing I talk about in the article, which is the derogation canon. They say, well, it's true this statute is silent as to any defenses, but we think Congress, if it meant to abrogate common law defenses, it would have told us. And so and they're only reading the codified version, and they're not reading the notwithstanding clause, because there's no reference to Congress abrogating common law defenses, we're going to assume they meant to preserve them. And one of the defenses we think existed at common law was this good faith defense. So that's why there's really two mistakes the Supreme Court is making. One is, as you said, not paying attention to the notwithstanding clause, and the other is this application of the derogation canon in this 1967 decision.
So what they're doing, right? Again, what the Supreme Court did was they just assumed in 1967 in the Pearson decision, they basically just they came out of nowhere, the Supreme Court, and said, "Oh, we think state and local officials should have a good faith defense." Right? When we read the statute, it doesn't say they can't have a good faith defense, and so obviously Congress, they're okay with them having this defense. That's how it went. In 1967 was the start of this, right? Was the start, or really when qualified immunity was born. What's interesting, of course, is the act itself was originally passed in 1871. It did not really, it was not used offensively, right, to sue people the way we have it today until later, several years later. And I do have some discussion on that, but I'm going to save that for another video. But of course, once courts were presented with it, they twisted these canons, right? The derogation canon, and interpretations to find. They basically created out of thin air a good faith defense. Even though now we know that that good faith defense was under this idea that Congress did not strike defenses, but we now know they intended that these cases proceed without the use of defenses. But somehow, some person back in the day, 1874, was able to just somehow erase or not copy or who knows what that very important provision. And so that's the issue we have today. So, Lisa, to answer to answer your inquiry, you're talking about qualified immunity isn't going to disappear anytime soon. I like to I would hope that's not true. Right. Here's what I would tell you. The Fifth Circuit, the most conservative appellate court in the country, has already addressed this issue, specifically Judge Don Willett. Unfortunately, all they can do is speak to it, write it in their opinions. But until the Supreme Court takes it up, nothing's going to change, right? I acknowledge that. But here's the kicker. The more times that this issue is raised in cases, right, across the country, the more and more judges are going to address this issue. And the more that the judges address the issue, one of two things is going to happen. There's going to be a split across the circuits because you're going to have one judge with a backbone who ultimately says this is unconstitutional and it needs to I'm not going to consider qualified immunity, and then it forces the Supreme Court to address it. Or so many judges cry essentially for help and say, Supreme Court, look at this. What are you going to do about it? Now, is that going to happen like overnight? Probably not, right? I don't think it will. So but yeah, obviously, Supreme Court is going to be the most direct path. However, a lot of the discussion I had with Professor Reinert was also it would be an easier path to have state legislatures incorporate qualify, get rid of qualified immunity. So you're bringing state law claims, right? Just like what they did in Colorado and New Mexico. Now, I believe I have to do a little bit more research on what the caps or what those issues are, but it's easier to change things on the state level, right, than it is obviously the federal level. I mean, federal level, I don't know how anything will change. I mean, right? Like right now, they can't even agree on a budget or paying bills. So it's easier on the state level where you can change, right? Why? Because you have a more direct link. All of you right now, you probably know, or if you don't know, you should find out who is your representative, right? They usually sit in small districts, so they don't have a lot of voters to answer to. But guess what? They answer to you. And you should point out to the extent you can, if you notice that there's a lot of issues with police departments in your area, you need to be talking to that state representative or that state legislature and forcing change and saying, hey, look, what are your concerns? Are your concerns that the cop's going to go broke or the city's going to go broke? Well, you can include in a bill that not only is there no qualified immunity, but maybe cities are required to set up funds or insurance policies to be able to pay for these things. And at the end of the day, how do you fix it? Well, train better, make sure you have the right qualifications, and hold bad cops accountable. It's that easy. And you're not going to have these issues. If your concern is you're going to have a bunch of cops who just aren't, who are going to go out there violating rights and you don't want to be held liable for that. I mean, it sounds like there's an underlying issue there that needs to be addressed. The derogation canon. What is? Can you explain that?
Sure. So in general, whenever you're interpreting a statute, there are these so-called canons of construction. They're basically shortcuts that we use for trying to figure out how to interpret a statute where the statute isn't obvious, where it's not obvious how to interpret it. One of those canons, one of those old canons, was called the canon that basically we should not um, infer a repeal of common law rights. That is, if there are common law rights, then the legislator will tell us they mean to do away with them. So it's a canon that is against the derogation of common law, essentially. That is, we shouldn't infer a derogation of canon of common law. Now, the key thing about this derogation canon is, number one, there's lots of people who basically for centuries, or for at least a century, have criticized it. It's really a way to undermine statutory authority and to ensure judicial supremacy. So it's been criticized for a long time. But one of the things I do in this article is show that even when it was sort of accepted and even when it was applied in the 1800s, generally it really wasn't applied for common law defenses like qualified immunity. It was applied for common law rights. It was like an early due process sort of jurisprudence that said, no, if I have a right in common law, maybe it's a property right, maybe it's a liberty right, maybe it's a right of action. Um, the legislature shouldn't just be able to do away with it silently. They should have to say if they're going to do away with it. But a defense was never treated as a right. And so this is all to my argument that, okay, well, look, even if the derogation canon is viable, and there are lots of reasons to suggest it's not, it doesn't make much sense in the context of a defense, and it certainly doesn't make sense in the context of a newly enacted statutory right like what Section 1983 was in 1871.
So, and if you have not looked up who Professor Reinert is, he is a well-established professor when it comes to advocacy, right? Civil rights, prisoner advocacy as well. Over at a Cardozo Law School, he's the Max Freud professor as well. So that the professor is selected because of these issues, and he has written heavily on this. And so when he says, for example, that this canon was used incorrectly and that the law is being, that's hard. That is hard in our community, right? To be able to find well established people out there who have spent their whole lives studying and advocating. And he's a current litigator, he still litigates today. And so for him to come out and say that qualified immunity is flawed, I mean, that's a pretty big deal. And then Justice Don Willett as well. If you haven't read some of his opinions on these cases where this has been brought up, where he's bringing caution and saying, "Hey, this is groundbreaking. We need to look at this." The community of common sense people, whether conservative, liberal, whatever, when they're seeing that the text is written a certain way and it's not being applied that way, something has to change, right? I mean, common sense down to your core, common sense is going to tell you it needs to change, right? Especially when you have to jump through hoops by applying, for example, different canons or different methodology to be able to keep qualified immunity alive when it otherwise shouldn't be. I'm not here to argue facts, how to bring this up in a case. Well, that's perfect. So, whenever there's a motion to dismiss, and I'm actually going to do a short clip where I'm actually probably going to provide like standard template for an argument because the argument should ultimately be the same regardless. So, when there's a motion to dismiss on the basis of qualified immunity or a motion for summary judgment after discovery for the basis of qualified immunity, normally what happens is there's two arguments, right? The plaintiff has the burden, so the plaintiff would make two arguments. The first would be this officer violated my rights because of X, Y, and Z. And these in this conduct that the officer did violated clearly established law because of these cases. That's the normal process. But now what should be happening in light of Professor Reinert's research is the very first question should be, right? The qualified immunity defense or issue is unconstitutional. That should be the first argument where you say it's unconstitutional because when applying the statute as written, it says that defenses are not allowed to be used. So for that reason, qualified immunity shouldn't exist. And then you put it up to the court, and the court has to acknowledge it. The court's either going to say it does exist or it's not. But what have they been doing? The district court levels on some of them have been actually finding, right, that qualified immunity is unconstitutional, so they're not going to apply it. Or if they were going to apply it, they're going to say it doesn't matter. They violated clearly established law. So you've had district courts who have been willing to actually side specifically with this research. And I'm in the process of compiling all that right now as well. The issue becomes when it gets to the Federal Court of Appeals. What you're getting is appellate courts are not willing to take that same leap, right? Appellate courts are still saying, well, because of stare decisis, because of the Supreme Court, we're just, quote, middle management. We have to say what the Supreme Court says, but we are concerned with all these issues. However, it's not for us to change the law, right? That's what we're getting right now. What we really need to do is we need one of these appellate courts to take, to question whether or not it's constitutional, right? That should be the first and foremost analysis I think they should be looking at. Is this constitutional? But no appellate court has done that yet. And I think they'd have a good argument too, because it's not like they're just directly rejecting Supreme Court precedent. They're doing it based on this groundbreaking research. That's what courts have called what Professor Reinert's research groundbreaking, because everyone's been applying the wrong law for over 150 years. So, doesn't it make sense to apply a new standard if everybody acknowledges that the law being used was wrong? So that would be my argument. But so basically what you're saying, because it's usually looked at for rights and not defenses. So when courts have applied the derogation canon to qualified immunity, they're treating it different than how they've applied it
Yeah,
elsewhere.
and if they're treating it differently than the how they've applied it elsewhere, and if the thing we're trying to do when we're interpreting Section 1983 is we're trying to interpret what the 1871 Congress wanted, there's no reason the 1871 Congress would have thought that they needed to write something into the statute and say, "Hey, by the way, you can't apply qualified immunity or, a good faith immunity to this statute." Now, the notwithstanding clause, makes the point even more, right? The notwithstanding clause says, yeah, so even especially in the context of this Civil Rights Act, it looks like Congress didn't want these common law defenses to be available. But even if you ignore the notwithstanding clause, right, you still shouldn't be using the derogation canon to imply these rights. So one of the things I did is I went back and I read every Supreme Court decision from 1798 up until 1871 that applied the derogation canon, and I couldn't find a single one that applied it in the context of a defense. It always treated it as a canon that was about common law rights, common law rights that had existed for a long time, not some common law defense.
Do you know if that argument was made though or unless they just didn't know the Supreme Court was going to apply the derogation canon in that manner? Was the argument made that, hey, you're not applying it
No, I don't
correctly?
think it was really. There was some discussion of the derogation canon in the 1967 decision Pearson, um, but I don't think anyone really had done the deep digging about it, um, uh, and about how it had been used in the 1800s to really make that argument.
All right. So any questions about uh, any questions about that? Let me see if I can bring up this flow chart here. 1 second. Cool. I'll move myself out of the way here. Delete laws. Guess what, man? I think you are my first super chat ever. Uh, so I'm going to go ahead and read it for you. The courts are broken. We don't get a square deal in state court or federal court. We typically lose at district court and have to appeal. Once there, it's a coin flip. Typically lose on qualified immunity. Yeah, I mean so that's what makes my job difficult as a lawyer, right? So let's be real about that. I get, it's actually sad the amount of people that reach out to me because their rights were probably violated, right? But I can't just take every case because someone's rights were violated. I'm one guy. I have my team, and we have to evaluate a case because it's not just getting to federal court or to appeal. The problem is you got to think about the time investment to get there, right? And then also the cost. Just to file a lawsuit, you're looking at $400 to $600, right? Then you got to have them served, depending on the number of parties to get served. That's another couple of $100. And then if there's excessive force or there's some kind of damage model that includes your like lost wages, mental medical issues, you're talking about all these experts, and experts cost money. And then you're talking about, and experts aren't cheap, especially police experts, right? Because you're asking cops, former cops or current cops, to basically call out other cops. And hey, John Eagle, appreciate that, man. Smash the like button. That's what he said. I agree with that. Smash up. I got another one. I gotta keep up. BZ Watchdogs. I beat yours. Love you, Chili. So that's the issue. So when you reach out to a lawyer who's talking about qualified immunity, or they got to evaluate your case, that's why, right? That's why it's so difficult, because these lawyers are understanding, especially if they take your case on contingency, that they're investing time and money with the understanding that there's a high percentage chance that your case gets dismissed, right? And that's a real concern. And the only way, unfortunately, to understand how to do these better is, you have to take cases and you have to lose and you have to hope that maybe you have a situation where the court could side with you or you change the law. Now, the benefit, of course, is when you lose a case, right? I've had this happen before. When you lose a case, like these groups, like uh, nonprofits, like the Institute of Justice, if they like your case and they think there's a chance to advance it, they'll join in, right? They'll take the case up on appeal. They helped me with the Bird v. Lamb case, which I did a video on. That was my client. They jumped in and they helped us take it up to the Supreme Court, right? Unfortunately, we lost, right? Because Bivens, we lost that case, but they helped us out. I'm not licensed in the Supreme Court, not yet. I've never practiced there, but the Institute of Justice came in and they helped us out with that. And so when you get that information, or when you get that help and that resource, you want to be able to use it, especially if you know you lost, right? Because that's the worst feeling in the world. We fight, 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 fight for years on a case, spend tens of thousands of dollars, hundreds of hours, and then on the eve of trial, the court kicks the case out. And then what do we got to do? We got to say, well, we lose all that time and investment, or we spend more money and more time filing an appeal. And that's the issue, right? Because then you don't know. You're going up on appeal as a loser. And then my scenario, when you're going up to the Fifth Circuit, I got to go up in front of the most conservative court in the entire country and basically tell them, hey, this cop does not deserve qualified immunity. It is an uphill battle, and I want to make sure you all are understanding that. So, Hill v. Moraine, your federal lawsuit against APD, I assume, Django, that's Austin. And it 25. So that's a case you filed this year. Interesting. Yeah. I'll write that down and I'll take a look. I don't know if you have any questions about it or concerned about qualified immunity or whatever. 125. Oh, obviously, I want to be careful what I talk about on any live case, whether it's yours or mine, because you don't know who's watching, right? I assume uh I assume a number of people opposing counsel, all that stuff. I assume they probably had no idea that I started YouTube. I'm sure after last week, they probably know now, right? I saw a comment about um posting this flowchart. Yeah, I could do that. If I can put I can post it on Twitter or X. I think I put it in the description. I'll put it in the chat as well, but it's the same as my YouTube name. So, and obviously, if you're represented by counsel, I don't, I'm not trying to use this platform for solicitation or anything. Hmm. Oh, using my wife's cup here. So, not using this for solicitation, but if you do reach out to me, just for everybody out there, if you do reach out to me, make sure you're clarifying that it's make sure that it's clarifying that it's the purpose of you reaching out is to seek legal services. Because if you do that, then our conversation's protected by attorney-client privilege. And so if opposing counsel or a defendant in any of these cases wanted my communication with you, that'll protect it from disclosure. But if you're just reaching out to chit chat, just I want you to be aware that there could be a risk that that stuff could be disclosed. So just make sure you're saying, "Hey, I want to seek a consultation. Check out this case, whatever." And then I got to process because I think we get 100 200 calls, contacts a week. So we gotta get through all of those. One of my most memorable cases that you were involved in from Pink Camera Magic. The one that, it really wasn't a 1983 case per se. I mean, the Leon Valley one was pretty big for 1983 just because the breadth of that case. And there is a protective order still. I tried to get that lifted. I wasn't able to get it lifted. And I'm not going to talk about current cases in litigation. So the two cases that would obviously stick out with Leon Valley, just because of the breadth, right? The number of departments that were involved in that, federal, state, local, the amount that the amount of data they amassed trying to hunt for charges. You want to talk about just think like January 6th level, but small Leon Valley, small town Leon Valley, because they think that people who engage in like First Amendment auditing are quote extremists. I mean they've said that in multiple cases, so that was pretty memorable. The other one that really meant a lot to me was I sued the state of Texas on behalf of a military spouse because the state of Texas was violating the Service Member Civil Relief Act. They weren't giving her a license to be a counselor, and under the act, they're required to do so. We were able to get the first injunction in the entire country and basically create law. Both the Leon Valley case and that case both established law going forward. The Leon Valley case was memorable because there was never a case on point that said auditing is an actual First Amendment right. I mean, you got Turner case, Turner v. Driver, that says you're allowed to film, but the actual practice of auditing specifically, Leon Valley declared, right? That case declared this is it's a First Amendment right. You can't retaliate against people for that. Delete laws, yeah. I asked that same question. I was thinking about that the other day about the acorn cop. Um, Custer Crazy Horse, 8616. Appreciate the super chat. What are the realistic chances of getting people's cases dismissed when every public servant has immunity and financial incentives for arrests made? Well, so do you mean criminal wise, like criminal cases wise? I the cases I've seen, when the arrest is bad, right? Because keep in mind there's a different standard for probable cause, right? To make an arrest, which is a lower threshold from uh beyond a reasonable doubt for criminal. A lot of times prosecutors will probably think that an arrest is bad and it ultimately gets dismissed. So a lot of times the cases I see are dismissed. If they're not dismissed, this is another thing I want you to know as well. Uh, BZ Watchdog. See you later. Appreciate you coming in. So the that's another thing. If you have an active case, it does not stay your statute of limitations. A lot of times, lawyers won't take the case while there's an ongoing criminal prosecution because you can't claim, for example, that you were unlawfully arrested if you were convicted for something you were arrested on. For example, I mean, there's nuances, but that's the general rule. So what's important though is so obviously you're going to have attorneys who are going to be like, hold on, reach out once it's dismissed. There is a caveat to that though. If you're coming up on your statute of limitations, like in Texas, it's 2 years, and your criminal matter is still not resolved, reach out to an attorney, raise the statute of limitations issue, and see if they'll take it. And what'll end up happening is they'll probably file the lawsuit or you file the lawsuit. And then the other side will probably move to stay the case pending the result of your criminal charges. And the reason for that is because there's something called a heck bar. Heck is a case that went into this. So if you ultimately get convicted on something, they're going to claim that your case is barred by what's known as the heck bar. And I could probably talk about that in a different video. I can I'll talk about the Nieves Bartlett as well. Uh, Probably not. Yeah. What the Nieves Bartlett does, which was just brought up by Delete Laws, 1984. And it's not really a discussion here. I mean, there's a lot of nuance there. But bottom line is, if you could show objective evidence that you were being targeted for your First Amendment activity, then the courts are not supposed to consider probable cause in their analysis, right? So you're not making a Fourth Amendment unlawful arrest claim where probable cause defeats it. You're making a First Amendment retaliatory arrest claim. And if you can meet the threshold in the Avis Bartlett case, Supreme Court case, I think from 2019, then probable cause doesn't matter. So there's a bunch of crazy stuff. Uh, Another question: how often is an unlawful arrest considered damages or whatever the technical term is? I mean, like at the end of the day, you're allowed to ask a jury, right? Hey, award me. You got to explain like how did it impact you? Obviously, if you're throwing somebody in jail, that's a pretty big deal, right? You're taking away their liberty. They don't get to go home to their families. They potentially miss work. And then just the reality of, hey, there's a difference between having the freedom of movement and being stuck in a jail cell. And I don't really know what value you could put on that legitimately, right? I mean, for purposes of settlement, when you talk to these officers, lawyers, they'll always tell you, "Oh, there's no real damages." That's kind of. I think it's all just talking points, though. So, all right. Me actually, I love being a lawyer. I love what I do. I've always wanted to be a lawyer. I hate qualified immunity. I like and love constitutional law. There's a lot of cases I don't like. A lot of cases I have to do, a lot of nuanced things I have to do. But when you know you have a great case, uh, and you could really run them through the ringer, or you're in a position to change the law, that's a really good feeling, right? So, all right, this flow chart here, back on topic. Um, so we have here both scenarios. These are got a little too excited. So these are the same law, right? 1871 here. Congress passes the Civil Rights Act. The side on the right, that's all green. That's what was supposed to happen, right? The side on the left with all the red and the bad colors, that's what did happen, right? So you have the notwithstanding clause, which basically says plain English, state law defenses don't apply. You get to file a lawsuit against state and local officials for violating your constitutional rights. That's it, plain and simple. No defenses. Unfortunately, in 1874, for whatever reason, the revisor deletes that clause. So it's read as you get to file a lawsuit, but it's silent as to any defenses whatsoever, right? So the court obviously assumes then that defenses apply. Isn't that nuts? So courts read the modified version silent on defenses. That's what actually happened. And you look here, what was actually Congress's intent, which is what they would look at. The intent is to protect newly freed Black Americans, right? This was right after Reconstruction. They didn't trust states to enforce the rights. And then it overrides any state law or barriers to liability, including common law. But when the courts go to read it, right, that's not in there. So as a result, they apply the derogation canon, which says we're going to look to the text. What does the text actually say? Well, the problem is the text they were reading was wrong or incomplete, so it omitted the defenses. So for the first time ever, the Supreme Court applied a statutory interpretation to a defense, a good faith defense that they have never done before and they had not done after this. And that was done in the Pearson v. Ray case in 1967, which for the first time established this, quote, good faith defense, which evolved into what we know today as qualified immunity. So, all right, and it shouldn't have been applicable because if the text was read correctly, right, the notwithstanding clause would have made clear what Congress's intent was, that the defenses should not have applied. So they would have never even looked at the derogation canon, because if they did, they would say, oh, Congress said no defenses. So, all right, let me, backing up a little bit, going through the chat, of any cases involving municipal police officers working with tow companies? Pink Camera Magic, are you looking at my case docket? I actually have a case right now that's actually up on appeal with the Fifth Circuit, so I really can't get into it. But the answer is yes. I do know of cases involving municipal police officers. You can look up, it's Kamichi. I can't remember right now who the named defendant is on that one, but the plaintiff is Kamichi. Okay, there was a question here about prosecutors. Okay, my next project I'm working on, I don't want to give up too much away, but I'm going to probably spill more in live chat. And so if you're watching a rerun of this live chat as well, and you don't like what's happening or that I keep getting off topic, well, come join the chat. Ask your questions. That's why I'm doing this, is really for people who come to the live chat. So my next project that I'm currently working on is to actually talk about the different immunities, right? Absolute immunity, sovereign immunity, qualified immunity, prosecutorial immunity, and judicial immunity. So more to come on that. So if you're not subscribed, subscribe if you want to see those drop. Okay. Yep. One trip can. I've not heard of Sheriff Adam King, but I'll write that name down from the chat. Out of Texas. Check that out, but if you can find a cause number for me and email it to me, that'd be good. Okay, let me see. We got a super chat here from Obi-Wan. Obi-Wan, $25. I appreciate that. The George Floyd Justice and Policing Act eliminates qualified immunity from all law enforcement officers. Please reach out to your congressperson to support it. Fix some issues of the botched interpretation for the past 150 years. Yeah, that's a good point. So the problem, the problem I noticed with the George Floyd Justice and Policing Act is it was a big movement, right, a couple of years ago, not just on the federal level, but on state levels as well. And the problem is, it kind of died out. That movement really died out. And so I don't think it's currently in front of Congress. I do know there were different drafts and different versions, and police departments were asked specifically to also incorporate rule changes. And I don't know if all police departments have actually done that either. I know there were some organizations that were going out and checking up and asking them, "Hey, police department, why didn't you make these changes?" But for whatever reason, over the last couple of years, right, I feel like that movement's kind of died out. But Congress, I mean, again, we can't even. They have their primary job is to pass a budget every year, right? Pass a budget, pay bills, keep the lights on, and they can't even figure that out. So we want them to go and uh, make changes to law enforcement immunities. I mean, I think that's a big ask, right? But yes, we should still at least be vocal about it. Otherwise, we're just giving up the fight, and I don't agree with that either. So let me see. Okay, I'm gonna drop my email here for this stuff. I want to obviously keep this separate from my law firm, but obviously I'm still a lawyer, answer lawyer questions. You can also go to my website as well, which is grable.law. Submit information through that. And then, yeah, through X as well, same name as YouTube. So, all right, back to this crazy alternate timeline for the qualified immunity as we know it. So, the Supreme Court, right, as we know, in 1967, they applied the derogation canon to say Congress didn't explicitly abolish common law defenses. So we assume they meant to keep them. But we know that's wrong. They just read the wrong text. So because the Supreme Court applied that incorrectly, there were two fatal errors, right? The first is the derogation canon said they applied it to defenses, and that has not happened the whole time that canon was applied. And then two, it had the missing clause. So the premise of qualified immunity was flawed from its foundation, and nobody caught it for over 150 years, right? So, and then the correct interpretation, obviously, is there should be no qualified immunity. And then, so the result of the flawed interpretation is qualified immunity was created, which we now have today. So the obvious impact on victims is even though there are violations to your constitutional rights, there is no remedy. And then laws never get clearly established. And then, for example, what I put in my video with my first portion of the interview with Professor Reinert. Remember, keep in mind, I have a number of videos and topics I'm going to put out, so you can get a complete understanding of that interview. But for example, out of the Ninth Circuit a couple of years ago, officers steal $225,000 worth of money, gold coins, Rolexes, rare comics, and the Ninth Circuit says, "Hey, there's not a case on point that says officers would have known, right? That it was clearly established that officers would have known stealing valuables while executing a search warrant. Uh, it violates someone's constitutional rights, so they get qualified immunity. How absurd is that? How like really? And of course, the Supreme Court didn't take it up, right? They didn't consider it, so that was the law. That apparently it was debatable, right? Because to be clearly established, it needs to be beyond debate. So what the Ninth Circuit was saying was it was debatable whether stealing someone's belongings during a search warrant, it's debatable whether that violates someone's rights. I can't understand that at all. So yeah, and if they get charged, that's another thing. If these officers are violating your rights, and I've had clients do it as well, file IA reports because I think it helps sell a story if the internal affairs isn't investigating or they're just sweeping it under the rug, or if it's a smaller department that they make complaints and it gets ignored. Juries aren't going to let them off the hook, or they shouldn't. The other thing is file criminal charges, right? In Texas, you can file charges. It goes to the Texas Rangers whether or not, I've not seen a case actually get prosecuted, but you're still making a paper trail and you're still showing how protected these guys are. And when it comes time to trying to settle your case or fighting it, that's important. So, and then if that one sentence back on topic on the flow chart here, if that one sentence, the notwithstanding clause, had remained right in 1874, we would actually have proper enforcement. The question would be, is there a violation? If so, there's liability. And then the law develops case by case, and then officers don't get to hide behind technicalities. And then rights have meaningful remedies. So, yeah, and then I think I saw a question here about charged with 242. That's a good, I don't know. That's, trying to get federal to charge anything. They have a lot of discretion what they want to charge. But obviously, pursuing litigation, right? That's a whole different ball game. There's immunities as to whether you could drag these people into court. So, all right, now I want to. Here's the thing. I do actually believe. Uh, you look at what the Supreme Court's been doing recently, right? So I like to think I have conservative viewpoints, right? Especially when it comes to the law, right? I'm like, the Constitution, don't expand it. It's like it is what it is, and and the rights are supposed to be inherent with the people. Small government. That's what I'm about. So when I see, for example, the Supreme Court going back and they're undoing things such as like the whole abortion issue, right? They said, hey, look, that's not really a constitutional issue. We really shouldn't just be making up rules because our job as a court is to interpret the Constitution, right? So that's how I see it. So, for example, the court is probably applying the right standard with as much as I hate it. Let me preface with this. As much as I hate it, I think the court is probably applying the right standard for Bivens, right? If you watch my video on Bivens, it's about seeking remedies against federal agents for constitutional rights. Why do I say that? Well, the ability to sue, right? Because the idea is the government had, common law history is government. You're not allowed to sue the government unless they give you permission to sue them. That's like the general flatline rule. And if the government is to be sued, they have to give permission to themselves to be sued. That's like how it's been that for the history of time. The Constitution does not allow like a special provision to sue itself, to allow its people to sue the government. But so that's why you look at 42 USC 1983. Congress is giving permission to people to sue state and local officials. The problem is they didn't expand that right to federal, right? So that's where I have a problem. I'm like, wait a second. So you're shutting the door on federal, like if federal violates your rights. Now you got the Federal Tort Claims Act. That's a whole different standard, whole different set of rules. And it's not about Constitution, but say a cop beats you up or whatever. It's possible you have a separate remedy. I'm not talking about that. I'm talking about, if they violate your First Amendment right, your Fourth Amendment right, whatever the issue is, you should be able to sue them, right? In theory. But because there's no statute or permission to sue itself, the answer really is no. But what happened with Bivens? Well, I think it was 1978. Don't quote me on that. The Supreme Court said you can sue under this circumstance. So they allowed for the first time a case to go forward. The problem, though, as you've seen in the video, is they have not expanded Bivens except under 3 total circumstances. So every Bivens challenge, every time you bring a federal lawsuit against an agent, if it doesn't meet the 3 categories that have already been decided, your case gets dismissed. But if that federal agent or that federal official was a state or local official, your case would have gotten to go forward. But what's happening? The Supreme Court is basically, think about this, okay? The Supreme Court's not expanding Bivens because they say there's no real authority to do so, right? Because Congress hasn't acted on it. But then you look at qualified immunity under 1983, and think about this, Congress has allowed, right? When you look at the original text, Congress has allowed those cases to go forward. But why isn't the court doing that? Why isn't the court saying, look, if the statute's allowing it, it should be allowed? Why don't they correct that mistake? Because I guarantee you, can't guarantee it, but if I could guarantee, if this issue gets to the Supreme Court where they agree to hear it, I think qualified immunity, as the way we know it, is gone. I really do. So what's the challenge? The challenge, of course, is getting the Supreme Court to actually agree to hear a 1983 qualified immunity case. And I hope on those cases where they take it up, that the lawyers remembered to make one of their arguments this text issue, this missing text issue. Because if they didn't preserve that and it goes up to the Supreme Court, that's going to be a problem, right? So let me see here. Where are we at? We need a agency dedicated for fighting for our 1A rights, the National Dues Paying Membership Organization. Yeah, I think that's you know, it's interesting because I will say, right, like someone brought up earlier, and maybe it was you, like the Nieves Bartlett case. That is a like to me, that's a pretty big deal. That is a good segue into trying to get away from like overcoming, for example, probable cause. Probable cause is so broad, uh, and courts will find probable cause with any stupid thing. And so if you can completely bypass the probable cause issue, I think that is one way. And I do think that the way to advance these qualified immunity issues that would actually interest the Supreme Court is probably through a First Amendment issue, if that makes sense. Um, yeah. So let me see what else. New case, Hamani about pot smokers, drug users not having a Second Amendment. Um, if the brewing case applies, right? The brewing case applies, says there's got to be you have to have a historical basis, and if there's not historical context of at the time of the founding when the Second Amendment was ratified, I mean, to me it's pretty simple. I believe pot was probably around back then, and if they didn't stop people from owning firearms, then it doesn't make sense that they could stop people from doing it today. So in that sense, also that's something that I thought. Someone correct me if I'm wrong. I I thought I saw something back when early on in the current Trump administration, they were talking about removing marijuana from its schedule list. I don't know if it requires Congress to do that. I thought that was just like a rule change, maybe with DEA. I have no idea. I'm not too versed in that process, but when you have a number of states that have already kind of legalized it, and federal government hasn't cracked down on that, I think the whole pot thing probably just uh, needs to change. And so it is interesting if you're exercising rights under state law, right? Texas hasn't allowed, Texas is completely banned. But if you're exercising your rights or freedoms under state law, can federal law then infringe upon your rights? It doesn't make sense to me that they could. And it also seems like they're being selective, right? I would argue, and maybe it is being argued, that it's selective, right? Because the DOJ has opted to go after presumably gun owners, but they're not going after people who are doing other things, right? Like having weed grow operations legal under state law, but obviously not under federal law. They're not going after them. Why are they targeting gun owners? I'm not, if you know me, I'm pro 2A. So that's what I would say there. All right. Bivens expansions, Fourth Amendment, legal. Okay, appreciate that. Delete laws. Yeah. So it has not been expanded based on what he put since the last case where they expanded it, 1980. So we've gone this amount of time. And there's been several instances where Bivens cases has gone up to the Supreme Court where they've actually considered the case, and every time they have refused, they've refused to expand it. So all I want is consistency, right? Use the same logic. If the Supreme Court's saying they're not going to expand Bivens because Congress has failed to act, well, on the same side of the coin, they need to get rid of qualified immunity because Congress did act back in 1871, right? See, be consistent. And of course, they probably know it. I don't know what their logic is or how they make decisions on what cases to take up, but I have a feeling we're going to see probably fewer and fewer 1983 cases actually being heard by the Supreme Court until they're ready to be confronted with this issue. So, all right, there were some. Let me see. So there were some interesting cases that came out this week. Every week, I look at this stuff, and so, hey, Brandon, have a good one. Um, cool name, by the way. So I'm going to go through some cases pretty quickly to kind of show you. Uh, it kind of highlights the qualified immunity issue that I've really been beaten up, right? So here we have out of the Eighth Circuit campus versus the city of St. Louis, Missouri, right? And so it just came out on October 31. And so St. Louis police officers arrested the plaintiff for trespassing on a highway as part of a mass arrest of protesters. Following the event, it brought, of course, lawsuits against all these people. The district court dismissed the claims, right, under 12b-6. So 12b-6, the initial motion to dismiss. So they're saying, hey, look, you filed your complaint. The officers filed a motion to dismiss before you got to do any discovery. And the court immediately said, yeah, you couldn't even get by that stage. And then they subsequently granted summary judgment in favor of the remaining officers based on qualified immunity. So what this sounds like then is that out of all the officers they brought, some of them, based on just the complaint alone, that's why complaints, and I'm going to have a different video on this, that's why your 1983 complaint, your actual lawsuit needs to be specific, more specific than a normal lawsuit, because you have to allege facts where if the court were to take it as true, that it overcomes qualified immunity, right? You basically have to assert facts that show a violation and that the unlawful conduct was clearly established, right? So they're saying for these officers, some of the officers, they failed. They were allowed to do discovery for other officers, but in the end, after spending all that money and time, the lawsuit failed at summary judgment, which is judgment without a trial. Basically, the court's reading all the evidence and concluding it doesn't get to go forward. And of course, the appellate court affirmed that decision. So the case, unless it goes up and gets revived by the Supreme Court, the case is dead. And if you look at the timeline, right? This happened back in 2017, right? Here we are, October 31, when this came out, 2025. So when I'm stressing in these videos, and this is without a trial, when I'm stressing in these videos how long these cases stay alive, right? Time is on the side of the government, on side of the official. So when you're making the decision to file these lawsuits, you need to be prepared to fight the issue for years. If you're not prepared to fight it for years, sometimes that happens. Sometimes you're like, look, I just want to get some money. Okay, fine. Tell your lawyer that. Otherwise, the goal is going to be, you need to be in the mindset it's going to take years. And at the end of it, you could lose. I'm telling you, most of the lawsuits, civil rights lawsuits, fail. That's no bullshit. That's the truth. They fail. So in 2017, the issue was there was a St. Louis cop that was actually charged with the murder of Anthony Lamar Smith. But in response to the verdict, presumably not guilty, there were protests that broke out for several weeks. And so, one protest on October 3rd, the cop was notified that there was a group of protesters marching on the interstate. They had, quote, intelligence detectives monitoring the protests, and that they were blocking traffic. So that's kind of my issue, right? Like, you don't, if you're going to protest, there's a difference between peacefully assembling, engaged in government redress, going to city hall, city council, sidewalks, whatever, or wherever you're allowed to get a permit for. But when you start blocking traffic, you really make your situation difficult in trying to get justice or remedies or whatever. Courts are not going to be like, oh, yeah, you were blocking traffic. Okay, well, you block traffic. We're going to give you your money. We're going to give you your relief. No, courts are going to protect cops. That's just the mode they're in. That's the mode they've always been in. So if you're going to set something up, you're going to go protest, go audit, go do whatever you're going to do, and you don't want your rights violated, just make sure you don't do things that can be construed as a crime. What does that mean? If you're on the sidewalk, someone wants to walk by you, get out of the way. You don't want any argument that you are somehow blocking the sidewalk, right? Same with the street. So another issue is, like a common thing I see. They go to arrest you, like in Texas. Even if they arrest you in Texas, an unlawful arrest, it is no defense to prosecution and no defense for purposes of a civil rights lawsuit. If you resist an unlawful arrest in Texas, that is a valid offense for resisting arrest. So what does that mean? If you get arrested, if the arrest started unlawful, but then you resist in Texas, you have just converted an unlawful arrest into a lawful one. And that means that if you go to sue that cop, you lose because you're resisting, at least in Texas and under the Fifth Circuit, you can't do it, right? So what I would tell people is if you're going to be unlawfully arrested, let them arrest you. Do what the court says. The courts advise people, don't fight the arrest in the street, fight it in the courtroom. That's the best thing you could do. If they're going to arrest you, let them arrest you. And you'll get your day in court if you wanted it. Because if the arrest is truly unlawful, I think I put in what Otto said in one of his videos is, he tells the cop, hey, you and I are about to be married because we're going to know each other real well for the next couple of years. So let me see here. Shuttlesworth, City of Birmingham, sidewalks. Yeah, sidewalks. Yeah, I'll tell you what, it's clearly established sidewalks, like universities, right? There was a case, I think there was a case in the Fifth Circuit that cited a bunch of Supreme Court case law at like UT campus, where if you also have campuses and they were handing out like leaflets or whatever, if you have campuses, public school, paid for by government funds, and it's open to the public, you also have a First Amendment right now there as well. Now, if there are obviously like permitting issues, as long as it's a fair process, you do have to follow those. But yes, definitely sidewalks has been established as a like a premier First Amendment location. For the viewers, I was addressing a comment that brought the case up. So here, blocking traffic, right? So the police are already aware of it. The protesters are walking, right? And then they exited the highway. And then when they attended the protest as, quote, legal observers, okay, interesting, to document police conduct and collect evidence for future litigation. I've never heard that before. So protesters were claiming to be legal observers to document police conduct and collect evidence for future litigation. Interesting. I might have to go pull the filing on this to get a little bit more. So unlike the marching protesters, okay, the plaintiffs did not step foot on the highway. So the plaintiffs here were not involved with blocking traffic, and no officer saw them on the highway. So now I'm starting to say, okay, this changes things. Plaintiffs, look at this. The court's acknowledging. Isn't this sad? We already know from the opening paragraph that they lost. But when we're reading right on page, like second paragraph in, the court's saying, hey, they lawfully stood there while the protesters were blocking the highway. So the court's saying your conduct was lawful, right? And then, so they're talking about what the protesters were doing, about the route they took. They got off the highway, went onto the grassy area. And then at the top of the off ramp, the protesters and plaintiffs, so they all got into one single group. And then the group was surrounded by protesters. So then the police officers were authorized to arrest individuals who had trespassed on the highway. So they basically were waiting for these individuals to get in a place where the cops could arrest them. So so that's what they ended up doing. The officer supervised the arrest within the encirclement, so they didn't allow any of them from leaving. And then the plaintiffs, unfortunately, were part of the group. So that's what it looks like happening. Is I'm not here to argue facts. You bring up a good point, right? There is a difference between lawful or constitutionally protected. Constitutionally protected, the court is going the extra step of making something clearly established, right? I'm going to show you why that's not so clear cut here. So the plaintiffs, so that's what ended up happening. Plaintiffs got tangled in with the actual protesters that blocked the traffic, got arrested, and they didn't like that because they're like, we didn't do anything. Hey, officers, you lacked probable cause. And then interesting, so they arrested all the protesters for blocking the traffic, and look what ended up happening. Not a single one. Apparently, even the protesters who blocked traffic were charged with the crime. So the plaintiffs filed a lawsuit, right? We're like, hey, you violated our First and Fourth Amendment rights. The Fourth Amendment's obvious because they're like, you arrested us for blocking traffic, but we didn't block traffic. And then First Amendment, because we're exercising our rights to, I guess, observe what was going on. And then, so of course, they filed a motion to dismiss. The court granted it as to one of the officers because I guess he didn't receive timely notice. So it looks like that one, they just never served him, is probably why. Or they served him beyond the time limits of statute of limitations or time limits prescribed by the court. So, but then the district court, so then they do discovery, they get all their evidence, and then they file a motion for summary judgment. And then in that case, once that happens, they basically file a summary judgment and say, hey, judge, we get qualified immunity, right? And that's what they said. So the district court found that the officers were entitled to qualified immunity as the First Amendment claims because of, I hate that phrase, arguable probable cause. Arguable probable cause is not probable cause. Matter of fact, courts will sometimes say that cop did not have probable cause. But because we had not determined this specific issue in a prior case, it is reasonable that the officer thought they had probable cause. So the fancy word for that, which actually I think originated in the First Circuit Court of Appeals, it didn't even come from the Supreme Court. It came from a different court of appeal that then just kind of rippled through all the other courts of appeal to include where I practice, the Fifth Circuit. And so if an officer doesn't have probable cause, but it's reasonable, meaning it's not beyond debate, that they could maybe possibly have probable cause, then they're going to get qualified immunity, even if they're completely wrong, right? So when you see arguable probable cause, the court more likely than not is saying they didn't have probable cause, but we're not going to punish them for it. It has to be obvious that they didn't have probable cause. And here, it's not obvious they didn't have probable cause. It's kind of what the court's saying. So the plaintiffs, of course, appealed, right, the summary judgment, saying, hey, the court was wrong. We want to be able to go to trial on this. And so when you appeal a summary judgment, you'll see things like, hey, we review these de novo. What de novo means is that the appellate court is going to take all the evidence, right? They're going to take the motion for summary judgment and your briefing, And then what's going to happen is they're going to kind of ignore, right? They'll read it, but technically they're ignoring what the trial court did, what the district court did. And then they're going to look at the evidence and they're going to do their own review from square one. And they're going to say, what is our opinion? And did the court kind of reach a similar opinion? If so, the appeal fails, right? And that's what they did here. As we saw, they affirmed the decision. All right, delete laws. It says that's the exact wording. In my recent case, yep, didn't have probable cause, but thought maybe he did. So granting QI. Yep, that's right. Arguable probable cause. It's they don't want to say, here's what courts could do, right? They could say, hey, you did not have probable cause, but I'm still giving you qualified immunity because it was not clearly established at the time of your incident. What impact does that have? Well, the next time this exact scenario happens, you can point to that case and say, hey, look, the court already said they didn't have probable cause in this scenario. Why did they frame it different? I think it's so they don't have to make it clearly established, right? They just say, oh, well, they're not going to say they didn't have probable cause. They're going to say they had arguable probable cause. Code word, they don't have probable cause. So de novo, they look at it, they say, we're going to look at everything. Now, if you've seen my videos on qualified immunity, you know what courts like to do. They skip question one. They don't answer whether or not there was a violation. Why? If they did that, it'd require them to actually evaluate the facts and conclude if there was a constitutional right violated by conduct. Why is that important? Again, it makes it clearly established for every other case that follows after it. If they never answer question one about whether or not there was a violation, it never gets clearly established. So if someone were to bring a very similar case to this, guess what happens? They could just throw it out. Not clearly established, not clearly established, not clearly established every single time. And that's what happens here, right? So you look to determine whether they're entitled to qualified immunity, two-part inquiry. Whether they demonstrated a constitutional or statutory deprivation. Question one, the most important question that any plaintiff in any civil rights case wants answered, right? Obviously, they want both answers, but they definitely want question one. Because why? Even if they don't prevail in the end, they know if it happens to them or someone else again in the future, they can move forward. And then question two, was the right clearly established at the time of the incident? It's got to be at the incident. So if the court comes out the day after you're arrested and makes it clearly established, you're SOL because your arrest occurred before a court ruling make it clearly established. Yeah. So, no, yeah. So someone just said because we haven't established that robbing a bank wearing a blow up shark suit is illegal, and the bank robber can't be shown to have reason to know what was criminal. Yeah, that's very similar. There is a exception that's rarely used, which is that if conduct is so egregious or just so blatantly obvious, I think that's the standard, blatantly obvious. Uh, then courts on occasion will grant or defeat qualified immunity, even if it wasn't clearly established. But there's a lot of subjectivity, right? The court has a lot of discretion as to whether or not something was so obviously wrong. Right now, I'll give you two examples. The Ninth Circuit case that we were talking about where the cop sold $225,000 and then got qualified immunity because it wasn't clearly established. Doesn't that sound like a scenario that would just be so blatantly obvious that every officer would know that they can't do that? It's almost like the judges have the ability to have common sense and say these things, but I guess it's just a different measure, who's sitting on the bench, right? I mean, it's common sense to me, maybe it's not to them. And then the other case, there was a Fifth Circuit case where talked about it in one of my videos where a prisoner was left in a cell for a long period of time covered in feces. The Fifth Circuit said, no, not clearly established. We don't have a case on point about this. It went up to the Supreme Court. The Supreme Court said, no, obviously this is disgusting and everyone should know this can't happen, right? So, so clearly established on this case, right? Look what ends up. Look what they end up doing. So they're like, okay, so it's got to be right beyond debate. That's the buzzword. It's got to be beyond debate. Or here you go, rare obvious case. So it's got to be an obvious case where the unlawfulness is sufficiently clear that even though if prior cases don't discuss it, right, they know. And then, of course, what I hate or despise is that courts have discretion to resolve under either step. So either they say one, there's no violation, so we're not even going to go to two. They don't really do that. They always just skip to two. Was it clearly established? If not, you lose, right? So, what do? They first look at the Fourth Amendment, right? The whole arguable probable cause. District court said, probable cause. And that's what they're saying. Was there arguable or actual probable cause? And then they go through their, Fourth Amendment analysis. And then just like 99% of these cases, maybe not 99, maybe 95% of these cases, the district court chose to begin in its analysis on the clearly established prong, right? So they're not saying the conduct was wrong, right? They're not saying the cops didn't violate their rights. What they're saying is, hey, you didn't prove to me or show me, plaintiffs, that the wrong conduct, the unlawful conduct, was clearly established at the time of the incident. So the courts don't even care if they start at prong two and you don't win on prong two, they don't care if the conduct was lawful or not. So that's what they did. So they're saying the district court did that. And then what did the appellate court do? We're going to similarly begin and end our analysis on the clearly established prong, as it is our prerogative. So they're saying we could answer question one, but we're not going to. We're just going to answer question two. Why? That's the easy way out. So they go through and they look at a number of cases, right? So here's what they do. Arguable probable cause exists when officers arrest a suspect under the mistaken belief that they have probable cause. That as long as the mistake is, quote, objectively reasonable. And so it's just if they had information to think that the arrest was supported by probable cause when obviously it wasn't. Let's see. Yeah, delete laws. I'll check that case out. That sounds interesting, especially since it's a Fifth Circuit case. I may have actually read that. It sounds a little familiar. So what they do is they go through the appellate court here, then goes through this Bernini St. Paul case. They're saying it's instructive. And then what they're going to do, and this is what courts like to do, they're going to distinguish the facts. This is where courts have a lot of leeway and discretion. If the court likes your case, they can obviously suggest that the facts are similar enough to where you did say it was clearly established and you get to overcome qualified immunity. If the court does not like your case, they could easily look at the same fact pattern from a prior case and find the slightest differences to conclude you didn't meet your burden, right? So they look at the St. Paul case and they're like, hey, it's pretty similar. It's about the protests during the 2008 RNC, right? After officers closed the downtown area, there were 100 people gathered at the intersection, right? And then it grew to 400 people. And then the officers encircled the group, told everyone they were under arrest, and they they released 200 people and arrested about 160 people. And then they were talking about that out of that arrest in 2008, the 160 people, 9 plaintiffs were not present at the intersection, did not violate any law, but were within the range of objectively reasonable police conduct. And then they talked about there was a practical dilemma faced by police officers responsible for reacting to a large group activity. So you can see where this is going, right? So the court found that the Fourth Amendment is satisfied in that case, right, where the officers have grounds to believe that the persons arrested were all part of a quote unit violating the law. So in that case, it was objectively reasonable for officers to conclude the marching protesters acted as a unit. So at the end of the day, um, that case held that the officer conduct was lawful. So what do you think they're going to do in this case? They're going to say, hey, look, it's pretty similar, right? Then what they do is they take that case and they're like, okay, what happened here? Well, the protesters surrounded the plaintiffs, and then the entire group, right? They're going to try to now group them together, proceeded, headed northbound. Plaintiffs made no attempt to distance themselves. They're going to say, hey, plaintiffs, I know you don't know you're going to get arrested, but if you knew what you didn't know, you should have done something to distance yourselves. Like, what? Okay. And then what ended up happening? They ended up, here's the key word, plaintiffs were part of the unit that engaged in unlawful activity. So, given the large number of people, requiring officers to make probable cause determination as to each individual would be practically impossible. So, in the end, what ended up happening was they failed, right? And how did they fail? Well, the plaintiffs failed to identify any cases holding that protesting's one innocence is enough to negate probable cause. So they're like, hey, look, they should have known because we were telling them when they were arresting us, we weren't part of that group. But what ends up happening? So you see, the court said you didn't do anything to distinguish yourself from the group, but then they didn't know they were going to get arrested. And then when they started to get arrested, they told the cops we weren't part of the group. And so what does the court say? Well, you can't. The court that cops don't have to listen to that. Which is true. They don't. They don't. Can you imagine every time someone gets arrested and they say they're not breaking a crime? I mean, even if they're not breaking a crime, look how the cops treat it. They're like, yeah, we don't have to listen to you. They're going to live and die on the sword as to whether they thought they had enough facts on their own to arrest somebody. So officers are not required to make individual probable cause determination before effecting a mass arrest. Here's the key thing. Normally, they are required to make individualized probable cause determinations. But there's an exception when it's a mass arrest situation. Back as far as you go back, history of law, it's always been you have to have individualized probable cause determinations. Somewhere along the way, the court said, "Oh, yeah, we can't do that. We got to make this rule for mass arrests." And that's what they did, right? So, all right. So, since basically what the court's saying is cops weren't required to determine if the plaintiffs had broke a law or not, committed a crime or not, because they were part of the same unit. There's probably if they had probable cause to arrest one person of this mass group, essentially they had probable cause to arrest everybody of that mass group, right? So that's the issue here. So as such, we find defendant had arguable probable cause to arrest the plaintiffs, right? So a whole bunch of talk just to get through that. And then they looked at the retaliatory arrest for the First Amendment. Problem is, they're probably going to, they already determined they were, that they thought they were part of the group. They didn't have other information to suggest otherwise. I bet that's what they're going to do, right? So here we go. So even though they're talking about the First Amendment, what do they open the second paragraph with? Well, in analyzing the Fourth Amendment claim, we concluded they had a probable cause. Well, generally, unless there's an exception under the Nieves-Bartlett case, which I'll talk about separately, but generally speaking, even for a retaliatory arrest under the First Amendment, probable cause would otherwise defeat that claim. So, since there's a finding of arguable probable cause, it means that the First Amendment right is also not clearly established, right? So, for that reason, they lost on the clearly established prong. They never addressed whether the conduct of the officers, right, in a future scenario is it violates, it violates a constitutional right. They just say, yeah, it wasn't clearly established. At the end of the day, they seem to admit the cops did not have probable cause. They had arguable probable cause, So they probably did unlawfully arrest you. Maybe or maybe not, it violated your rights. We're not going to answer that question. But what we do know is the officers have the defense of qualified immunity. So it doesn't matter. So, all right. And then we have this case out of the Sixth Circuit Court of Appeals here, right? So the plaintiff claimed that I don't know this officer's name, used excessive force by tasing him. Uh, by tasing him, excessive force by tasing him during arrest. And then, of course, moved for summary judgment. So they were allowed to get discovery presented to the judge. And essentially, what ended up happening here in the Sixth Circuit, so this was in Ohio, the trial judge actually denied the motion and was going to let them go to trial on this. So, unfortunately, though, it goes up on appeal. The officer, right? If you've seen my videos when I talk about these steps, every step, if qualified immunity is denied, there's opportunity to appeal. So the district court said, yeah, I'm going to let this go to trial. But the officer said, hold on, I'm going to take advantage of my opportunity to appeal it before trial. And of course, if it got to go forward to trial, there'd be appeal post trial. But unfortunately, in this scenario, the Sixth Circuit determined that the trial court was wrong. This officer gets qualified immunity. Can you guess which prong the appellate court granted qualified immunity on? Do you all know? If you said the clearly established prong, you'd be correct. So the plaintiff was, I guess he needed to take his medication running errands. As a result, blood sugar dropped. Yep, that's right. Second prong. Began driving erratically, resembling intoxication. So, of course, the cops go to pull him over as a result, right? And they saw based on his license that he had a concealed carry weapon permit. So he walked up to the truck window, found him slumped in the driver. Oh, dude, didn't want to do that. Found him slumped in the driver's seat, right hand gripping the handle attached to the A pillar, and then so obviously there was some issues. So the cop tried to ask him how much he had to drink. There was no reply. Instead, turned his head towards the passenger side, and then the cop said, "Step out of your vehicle." But he did not immediately respond, rubbing his forehead, adjusting his hat, and then arcing his head and body towards the passenger side. So, what we have here, obviously, is right. This guy, there's something going on, right? There's obviously something going on. The cop just automatically assumes he's intoxicated. No way this could be a medical emergency, right? So even though the plaintiff tried to get out of the vehicle, he repeatedly turned his head towards the passenger side. Bottom line is, they end up getting in this tussle, right? And so the cop begins to pull him out, and then he says he tensed his body. I hate that phrase. Tensed his body across his own arm over his chest. So in response, the officer unholstered his taser and then warned him he would use his taser if he didn't get out of the truck. Now keep in mind, there's a medical emergency taking place here. And the cop's not even thinking about that. He's just like, oh, I tried to pull this guy out. He's tensing up. I'm now going to taser him. Like, what? So 3 seconds. 3 seconds. Imagine. One, hey, get out or I'm going to taser you. And then told him he was under arrest. At the same time, he fired his taser at his stomach and then continued to taser him as he tried to pull, as the plaintiff tried to pull the prongs out of his stomach. And then the officer brought the taser close to the body to then perform dry stun, but backed up and continued to tase from a distance. And then the officer went in to dry stun him again and then pepper sprayed him in the eyes and then pulled him out of the truck by his arm. So how many times is he tasering him, pepper spraying him, and then pulling him out? And then, of course, handcuffs him. And then at that point, when the paramedics arrive, he regained lucidity to respond, who asked if he was diabetic. So the paramedics knew. I mean, these officers go through first aid training. Don't confuse that. They definitely do. And these are probably one of the things they were taught to know is like, hey, these are signs to look for, especially if someone's diabetic. So the idea that this officer didn't have that training, he probably just ignored it or he didn't remember. Who knows what his excuse was? But the paramedics knew, hey, are you diabetic? He said yes. So he got taken to the hospital. And then, of course, he got sued for excessive force. And there's a lot of tasering cases out there where, especially when you keep tasering somebody or you keep pepper spraying and you don't know when to stop, especially if there's no reason, right? There's something called escalation of force. So these guys have to be doing something, I think, active resisting. There's a difference. I'll talk about that later. But at the end of the day, you got to be elevating your resistance to allow the officer to elevate their resistance based on what we read. And maybe there's video, but based on what we read here, there is nothing to me as a civil rights attorney that suggests that the plaintiff was escalating his resistance to the level of active resistance that would have warranted or justified this officer tasering him the amount of times he did. What he should have done was just taken a break and just pause, right? He could have done that, but he didn't. So I understand why the district court would have allowed the excessive force claim to go forward. You got to go through the Graham factors, right? You got to look like, was he, what was the seriousness of the crime alleged? Was he a threat to others or the officer? Was he trying to flee? He wasn't doing any of those things. So the court, of course, denied the motion to excessive force. I guess there were state claims as well. And then, of course, what do these courts do? Right? They basically have to. Okay, here you go. So real quick. So it looks like that the district court acknowledged that maybe there was material fact, whether it was active resistance versus uh, resistance, passive resistance. So again, we see that word, right? De novo. So they're going to just look at everything from the beginning. And then they talk about the qualified immunity prongs. Like they just, it's kind of like copy and paste through all these, right? So in other words, plaintiff has to show they violated a right, the one we want, answered every single time. And then was it clearly established? And then what did the court do? The court immediately jumped to the second prong. For right to be clearly established, the plaintiff has to show, right? The plaintiff has that burden to show that there's a case that gives fair notice, right? That the constitutional question was beyond debate. And the plaintiff has to point to a closely analogous precedent with facts like the ones at issue here. See the high threshold? They don't even care if there was a constitutional violation. They're asking plaintiff, hey, we don't care about that constitutional stuff. First, tell us, was it clearly established? Have we decided this issue before where in that prior case we answered question 1? And of course, plaintiff failed to do that, right? That's what they say. We need not decide whether a constitutional violation occurred because Mills has not shown that the officer taser use violated clearly established law. Right? What did they say the district court did? It said, hey, the district court applied the clearly established analysis wrong. What the district court did was they said the district court counted as an affirmative defense. So what ended up happening was they were saying, hey, since the defendant raised the immunity, it should be the defendant to prove it, like every other defense, except qualified immunity. Qualified immunity, right? Once the defense is raised, it's the plaintiff that bears the burden. And so they're saying, hey, district court, you did this wrong. You did not put the burden on plaintiff. So as a result, qualified immunity. Now, here's the problem with this case. Let's say this officer or another officer in this circuit, Court of Appeals, goes and pulls someone over, similar circumstances, and tasers them today, right now. It's still not clearly established, even though the plaintiff in this case spent the time and money to go through this process, summary judgment. So they've already done discovery. They've already probably gotten experts. Medical, there's probably medical stuff going on. But because the court decided to ignore question 1, this case serves no purpose going forward. So, not established. That's right. All right. Hey, Bulls Deep, have a good one. Um, all right. Probably going. Yeah, let me see. I will say, I'm just glad I'm not here kind of talking to myself. I know the last couple of streams kind of getting my feet wet, kind of getting the tech stuff set up. So I appreciate you all that have kind of hung around for doing it, but no pressure. This is really just for me to kind of get the exercise and to reach, to the extent you all have questions as well. So then, real quick, I'm going to go to the Fifth Circuit case. There was a Sodom City McAllen. This is what sparked my interest with this specific case. It's a Monell liability issue, and for Monell, that's when you're suing a city for violations, right? And it's a completely different standard than qualified immunity, right? You have to show a. So here, the court granted summary judgment to the city of McAllen, right? Because what he was saying was he was trying to say that the city of McAllen had a policy, right? When you bring a Monell claim, you're trying to get liability on the city. Otherwise, if you don't have, it requires a policymaker, a policy, or an absence of policy. And you have to show that the absence of policy or the policy that it was obvious that either not having a policy or having the policy that was obvious that it was going to result in the violation of rights. So I appreciate the support, guys. So in this case here, right, the Soto case, he's claiming, "Hey, I got assaulted in 2016." Right? Just think of the timeline. This opinion came out October 31, 2025, from a 2016 issue. Just to give you an idea, again, another case in point example, how long these cases go. And then look, I might have to look at this to use as an example because here it says the Fifth Circuit says we detailed the incident in a prior appeal. So there was a prior appeal back in 2023 before he ever got to trial. He's already on his second appeal. So what percentage of cases do appellate courts reverse a grant of qualified immunity? Do those cases have media coverage? I know there were studies. I don't think there were any recent case compilations. I do know that generally in the 1983 realm, right? I'd say it's probably 30% reversal, but it probably impacts plaintiffs more that overcome qualified immunity, and then the appellate courts would reverse it and grant qualified immunity. I'd have to look at that. Uh, Clinton, yeah, 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 reach out. I'll put my email here. Okay. All right, good deal. Yeah, under duress, hopefully not working too hard. So talk about media coverage. That was a motion I filed long ago. Uh, yeah, send me the case, BB, and let me look at it. How do you establish the precedent case so that something that follows is clearly established? Well, Obi-Wan, the way to do that is courts need to answer question 1. Okay. If the court says, so for example, you take the Turner v. Driver case, 2017 case out of the Fifth Circuit, uh, the court answered question 1. What, right? So if you know what Turner was doing, Turner was filming from a sidewalk in an FBI building. Police approached him and they wanted him to identify, and he refused to do so, and they arrested him. And so the question was, did the did you have a First Amendment right to film police and government officials performing their duties in public? Well, the obvious answer was they answered yes. It had not been answered yes explicitly before, But they answered yes there. The problem is they said, was it clearly established at the time of the incident? Well, the answer to that was no. So while Turner technically lost, right, on that issue, going forward, and I could probably pull up a Turner v. Driver has been cited all over the country, hundreds, maybe even 1,000 times now. It's a very persuasive case. And what's interesting is so going forward, so while he did not win on that second prong, it was critical and essential that the courts answered the first prong. Was it a constitutional violation to interfere with somebody filming government uh, officials? Well, yeah. I mean, it sounds obvious to you or I, but apparently it wasn't obvious until the Fifth Circuit said it was obvious. And then once the Fifth Circuit said it was obvious, every single arrest or detention or interference that occurred from that point on violates clearly established law. So that's why asking courts to answer question one is so critical. So critical. And now, what do we know from Professor Reinert's research? We also need to be attacking, before question one and question two, we need to be attacking the premise of qualified immunity. We need to be saying, look, it's unconstitutional. Here's the text of the language. Defenses are not allowed. And then just start from there. So in this case, he wants to go after the city, right? So what happened, Soto, during his DUI arrest, he was slammed to the ground, pinned, kicked while he was handcuffed, causing facial fractures, other injuries. To me, that's a big deal. Like, to me, when you see a situation where someone is getting assaulted while handcuffed, that's a huge, like in my, like, big deal. Like, how do you just, if the standard of a Fourth Amendment, which excessive force falls under the Fourth Amendment, if the standard is reasonableness, in most cases, how do you justify reasonableness by beating the crap out of someone who's handcuffed? Now, there might be circumstances, right? I'm not going to say under no circumstance, but generally speaking, most circumstances, it sounds unreasonable, right? So he brought the claims against both officers and then also a Monell claim against the city. He's saying the city, what the reason why, so you can't just go after the city just because they hire the officers, right? A lot of people may not know that. They're like, I'm going to sue the city because they got crap officers. Well, that's not the standard, right? It's not like an employer in a private lawsuit where you could say, hey, your employer screwed up, so I'm going to sue you. When it comes to cities, it's different. There's a high, like with anything with civil rights, there's a higher threshold, a higher burden. And here it's the plaintiff bears independent responsibility, or they're saying the city bears independent responsibility because they're saying the written use of force policy was too vague and they failed to train the officers adequately. So to me, this is kind of here's what I learned. As a civil rights attorney, you don't say that their policy is weak or garbage, right? You have a better argument making the allegation that there's no policy whatsoever, right? Or the policy is just constitutional. What I've seen, those are the two circumstances where the policy issue succeeds. No policy when they knew they should have had one, right? Not an inadequate policy, but no policy. Or two, the policy itself was unconstitutional, right? That's it. Those are the two key things. So already I know they're going to fail when I'm reading this for the first time. This is not my first time reading it, but when I read things like this for the first time and I see the allegation is that it was a failure to train adequately, unless you have a pattern and a pattern's, multiple times, not just once, similar circumstances, 3, 4, 5, 6 times, specific facts, it's probably going to fail because an inadequate policy is still a policy. And inadequate policies is not unconstitutional. Maybe not having a policy could be unconstitutional, and having an unconstitutional policy is unconstitutional. I hope that makes sense. So saying inadequate policy is not enough. So the city moved for summary judgment, saying that its use of force policy condones only reasonable, not excessive force. So again, here's another thing. A lot of people say, "Oh, well, the cop violated the policy." Well, that doesn't mean you get to file a civil rights lawsuit, right? Because if a cop violates a policy, it doesn't mean they're violating your constitutional right. It could mean they're violating your rights afforded under a policy, but you can't sue for that. Does that make sense? So yeah, the doctrine should not have. Someone asked, "Why does the doctrine survive so long?" Well, I don't think anybody caught it. Right, that was the interesting issue to me. So the policy at issue here for the city of McAllen is that police officers shall use only the force that appears reasonably necessary to effectively bring an incident under control while protecting the lives of the officers or others. So the policy here is, yeah, use reasonable force. Is it vague? Yeah, it could be vague, but is it unconstitutional? Reading that and out of all the policies I've read over the years, no, I don't think that's unconstitutional. At least how courts have interpreted. It is vague though. I give them that. And then it lists parameters for non-deadly force. That's known if you ever want to look it up, continuum of force, where again it's like what I can use open hand if the other party does this, or I can use hands on if the other person does this, right? It gives you an escalation of force or a de-escalation. That's normally in the policies as well that you need to de-escalate. So they found no evidence. So the trial court found no evidence of a policy or custom authorizing excessive force, nor a pattern of excessive force by city police officers. So, why is a pattern important? Well, a lot of times cities aren't going to put in writing, hey, you could beat the crap out of this type of person. They're never going to put that in writing. They're not stupid. But if cities keep beating the crap out of people, say, for example, someone that's filming them all the time, and the cop just keeps beating up these type people with cameras, right? Well, as long as you can show specific facts of this happening over and over and over again, courts will allow you to bring a policy, practice, or custom argument under Monell, which is the Supreme Court case allowing liability against the city. They'll allow that to go forward and say that, well, while it's not a written policy or practice or custom, through conduct, it obviously is. So that's why it's important to document those things. And it's a high bar because plaintiffs can't just say, well, this has happened before. That's not enough. You need to show specific instances, identify the dates and times, the people involved, what ended up happening, right? If you have a cop, right, and the most common circumstance I see is you have one or two bad cops. Maybe the rest of the department's not going to do it, but they all know who the troublemakers are. And these bad cops keep getting excessive force complaints made against them for similar things. You know, threw me out of the vehicle or did X, Y, and Z, right? And it's all the same exact issue. Well, now you can establish that the city has an unwritten policy of allowing this police officer that they know is going to interact with public to go around and assault people. So that's the key thing. So it doesn't even have to be a pattern in a lawsuit, right? It's just you could get that with that's why it's important to make complaints with internal affairs with the police department. And then if you're concerned about an officer, you go and do an open records request. Hey, I want all the complaints on this guy, right? Especially if you're going to intend to sue or whatever you want to see. Is there a pattern of practice of these particular officers? And again, it doesn't even have to be the same officer. I'm just telling you what I usually see. If all these officers or multiple officers are engaged in similar patterns, it's got to be similar. You get to Manel. Here, in this case, there was no evidence. No evidence. They just didn't like the way the policy was written. That's not enough. So, in what you'll see in Manel claims, it's not your qualified immunity standard, right? What they're saying is to overcome summary judgment, you have to establish that there is a genuine dispute of material fact, that there was a policy by a policy maker that was the moving force behind the violation. right? So it's really, they didn't number it, but there's 3 elements. You have to have a policy, policymaker, and it was the moving force behind your alleged violation. So simply saying that a policy is too vague, that it effectively authorizes unconstitutional force, I think the court's going to shut it down. Normally, they'll shut that down on that first prong, and then they're saying the failure to adequately train is another policy, right? That's going to fail as well. It's not enough. Um, and then so first, right, they're going to say no reasonable jury could find that the use of force policy authorized the violation, right? So they're saying, hey, look, by its plain language, the policy itself says force that's reasonably necessary. Even if it doesn't define it, it still says it, right? So, and plaintiff conceded that both officers involved were either terminated or resigned following disciplinary proceedings for violating the use of force policy, among others. So that brings up another point. When everyone is saying, "Hey, look, why don't you just sue, or why aren't these bad cops just getting terminated or fired or whatever?" Well, when and that's happened in my cases. When that does happen, you it's harder to sue the city because the city's almost admitting they violated policies, or they violated our standards. How do you turn around and then sue them, right? Here is a problem though, and here's what I've seen, at least in Texas. In Texas, cities hold an officer's license, and if they don't want to hold that license anymore, they have to document how are they discharging them. Are they, if there's a criminal investigation or some criminal liability, they give them like a dishonorable mark. And then what other city is going to hire them with the dishonorable mark, right? Probably none. What happens though is if they resign before there's a official investigation, then they leave under honorable, potentially honorable circumstances. If they leave under honorable circumstances, they're allowed to go get hired at other departments. And other departments in other cities are going to be like, "Oh, I didn't know about this crap. I got his license. It says he left under honorable terms." So those are the issues here. The issues are they allow the officers to leave to protect their license, or if they do fire them, they have to mark. Hopefully, they mark it dishonorable and not general or whatever. So those are always important things. But again, a one time situation, unless you have a policymaker that's directly involved in the decision making, Mandel claims are incredibly difficult. So, all right, and then second, of course, he has not established his claim that the city failed. So again, they're still in the policy issue that they failed to adequately train, creating an obvious risk of excessive force. So they shut the so see they shut this down on his two policy arguments, right? They're like, you just didn't give us a policy. So they didn't even answer or evaluate whether there was a policy maker or whether or not it was the moving force behind the violations. They simply said, you failed to prove a policy issue. Remember, no policy is good. If you could say you should have known you needed a policy for use of force, for example, and you didn't have one, or two, a policy that's just unconstitutional. Like if there was a policy that says you're allowed to taser somebody that you pull over immediately, right? That's obviously unconstitutional. So as a result, since he didn't identify a pattern of incidents, which would be a unwritten policy or a complete training omission, uh, his claims fail. So that's what happened there. So I that's what I have on those. I was going to talk briefly about if you didn't see it. Matter of fact, maybe I'll just pull up the article on it because I thought it was a pretty interesting case. I'm not going to go through the opinion, but I did want to talk about it because if you're big on the First Amendment, I think this case will be important for you. So the second Court of Appeals, which covers New York, there was a case here. Let me get this photo. So this kid, His name was, Case Leroy. He was at school. So this was a Snapchat, that he sent out, back in, 2021. Uh, he sent a Snapchat that was after school hours, away from school premises, but he shared it with school friends, and he's got his knee on this guy's neck, and it says "Cops got another." And of course, apparently this blew up, right? Like it got shared all over the state. There was media on it. There was, uh, there were demonstrations at school, schools where teachers were forced to talk about it. There were all these different things: demonstrations, protests, discussions, and so the school basically, they suspended this kid. They said, "Hey, even though what the kid did, once he realized it was wrong and people gave him hate for it after he sent it, he deleted it, he took it down, and then he asked other people to take it down. They didn't take it down, spread. He ended up getting suspended, and so he obviously appealed. And what ended up happening was the Second Circuit came out earlier this week and basically said that the school suspending him violated his First Amendment right. They were like, "Hey, look, this happened. You can't regulate speech, right? The school's a government entity, even a quasi-government entity. You can't regulate speech of students outside of school, right? Can you imagine? Can you imagine that? Allow kind of breaking the idea that governments can regulate even when they're outside of, you know, in this case, the school regulating a kid's speech outside business hours or whatever they call it. So that was a pretty interesting. Uh, that was a pretty interesting case, and the opinion goes. I was actually pretty surprised coming out of the Second Circuit uh, that they did that, but I wanted to share that. I did post a link to that case specifically on my X account. Um, but I thought that was good for the First Amendment because I any time we get to challenge government intrusion on any right, it's worthwhile discussing. It's worthwhile fighting. But anyway, I think that's all for me. A link in the chat for the case. I can actually do that right now. So, I before I sign off, are there going to be any questions or anything that you all have? Let me see. There's a New London, Connecticut case in the state Supreme Court where the court ruled unwise but lawful rational basis to reject top civil service applicants because inferior cops don't seek better jobs. Interesting. So here's the link to that Second Amendment case here. Weird. Says it's too long. Let me may I just link a page to the page, and then it's going to be the Leroy versus Livingston, and then again it's on my X as well. Let me see if I can figure this out. I don't really. I'm still trying to figure X out as well, but put that there as well. So, so what my plan is so for this channel, I want to do a number of things, right? I love what I do. I spend 7 days a week doing it, and I handle cases all over the state. I'm constantly reading, researching, writing, fighting, advocating. I constantly learning as well. And a number of people said I don't stream on X, no, but I post this stuff on X. Maybe I don't know. I don't truly understand X yet, but what I would like to do is I want to do interviews with different people, right? Professors, hopefully judges. Even if some of the crowd doesn't like it, I'd even like to see if I could get like police chiefs to come and talk to me about some of this stuff, and just get their perspective and get their reaction on stuff, and try to see, hey, look, objectively looking at X, Y, and Z, does this make sense? Right? So I'm looking at doing interviews, breakdowns, case evaluations, and obviously just education, period. Because if we can all understand and go into something, like if you want to go record or you want to go fight your own case or whatever, or you want to go get your case together and make sure you have a case, I want to make sure that I can provide a resource for you to completely understand what are the concerns, what are the pitfalls, right? Like a lot of people think, oh, I got a $10 million case. Well, the first thing is, what are statute of limitations? Can you get over qualified immunity? What's your actual damage model? What are the hurdles? What are the different issues you're going to be faced with? How long are you looking at fighting? I want to answer all of these questions. And I want to be able to do it not just with interviews, but breakdowns, but lives like this as well, right? Because I look at every single day, maybe not every day, but every other day, I'm looking at every appellate court across the country, and I'm looking at and reading decisions. Because another thing I can get over qualified immunity, if the Fifth Circuit hasn't decided an issue, but three other circuits have, for example, I can use that to hopefully get it clearly established in Texas. And so that's what I want to do. Yeah, lawmakers, I could get them on, get them on as well. So I want to be able to I want to make this like a one-stop hub. Obviously, I haven't thought about it before until someone mentioned it, but then I posted that deposition. As long as the case that as long as the case I have or the deposition's not bound by like a protective order, I'll probably post those as well. So you all would like to see a lawmaker on? Yeah, let me work on that. And if there's any topics or anything you'd like to see, I got a working list. Um, send it to my email, send it to me on X, and I'll add that to the list, especially if I think it's interesting. So, but I appreciate you all coming on. I appreciate the support. Uh, I've been doing this for, I think I started like 2 or 3 weeks ago, and the support, the growth, it really has been amazing. I had no idea what to expect when doing this. I'm still, bear with me. I'm still working through all the technical issues, right? I'm a lawyer. I can read, I can write, but trying to get the sound sync crap and the edits and this and that. And, I think, you know, trying to figure it out. I just, one day at a time. What can I say? So, uh, again, appreciate y'all coming on. But anything else before I sign off? All right. Well, you all have good night, and Barnes v. Felix. Um, yeah, CJ. Actually, CJ is a client. The CJ Everard case in Almost Park. Fought that good fight with him for years. But yeah, I'll probably see if I could get him on as well. I think I saw he's got a trial coming up, but we talk often. He's definitely a strong advocate in the space. I'm glad he became an attorney. All the crap with them trying to come after his bar license and everything there. It it's shameful. Just because they don't speak like him or advocate like him, it doesn't mean he's not an advocate. I think CJ is an outstanding advocate, and I think he will fight like hell for his clients. And if the state reps, the state bar can't see that, shame on them. But I'd go to bat for him every single day, no doubt. So, all right, yeah, I'll check it out. But okay, y'all enjoy the rest of your weekend. Stay safe, and yeah, keep eye out for some videos this week. And I guess I'll see y'all next week on the live. Look for